Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Welcome to the Environmental Evolutions podcast, where we explore the changing landscape of environmental law and policy. My name is Scott Novak, and I'll be one of the co-hosts on this podcast going forward, along with my colleague, Linn Bumpers.
Hi, everyone. Scott and I are both attorneys in Baker Botts' Environmental Safety and Incident Response Group, and we are excited to bring you the latest developments in the environmental law space going forward. And at this point, you're probably wondering, where is the podcast's usual host and founder, Megan Burge?
Effective March 3rd of this year, Megan will be Northwest Natural Holding Company's Deputy General Counsel and Corporate Secretary, as well as Northwest Natural Gas Company's General Counsel. We are thrilled for Megan, and before we begin today's episode, we want to express our gratitude for the mentorship she's provided us. I'm sure last episode won't be the last time you hear from her, as we hope to have her back as a guest in the future.
Speaking of transitions, today's episode will focus on the environmental implications and impacts of the new Trump administration's executive orders. We are excited to welcome Baker Botts partners Jeff Wood and Shai Sahay to discuss these developments.
First, a bit of background about these two. Jeff served for almost 2 years as the acting assistant attorney general for the Justice Department's Environment and Natural Resources Division during the previous Trump administration.
And Shai is one of the nation's leading thinkers on energy transition and environmental issues, with experience advising clients in the liquid fuels, climate tech, energy, manufacturing, and agricultural sectors and beyond. Prior to returning to private practice, Shai spent 6 years serving as in-house counsel at the largest biofuel producer in the world, including 1 year serving as the acting general counsel of the largest biofuels trade association. Thank you both for being with us today.
And I should note the date we are recording is February 18th, 2025, just in case there's any further developments after the recording of this episode. So, Jeff, starting with you, how is the start of this administration different from President Trump's first term? Are there any trends that stand out to you regarding the executive orders issued so far that could impact the environmental space?
Thanks, Scott. Yeah, there's a lot that's the same, a lot that's different. The most starking difference to me, and I'm have the perspective of somebody who started on the very first day of the first Trump administration at the Justice Department, is this go round. There's been such a laser focus on reorganization and staffing, which, as we've all read, has created quite a shock to the system. Large numbers of personnel have been either removed from positions or notified of their option to retire or retire early. And it's creating quite a lot of shifting within the agencies that we've all kind of among roles of people that we've dealt with for a long time. So that's been a big difference and probably the most significant and unexpected in some ways in terms of just the speed and the number of changes that are being made. But then if you look at the policy issues, very similar focus from the first administration to now the second Trump administration. Energy dominance remains a huge priority and a huge focus for the Trump administration, just as it did in 2017. Of course, in 2017, President Trump rolled out a series of executive orders over the course of the first few weeks, many of those addressing energy and environmental issues. In this second round, he issued 40 executive orders and other actions in the first day alone, many of those touching on energy and environmental issues. The speed with which those came out was certainly different as well. Similar concepts over at EPA in terms of a focus on clean air, clean land, and clean water. We see that as the very first pillar of EPA Administrator Zeldin's 5 pillars for powering the Great American Comeback. He also talks about American energy dominance as a key pillar for his tenure as EPA administrator, along with things like permitting reform and cooperative federalism. So all very similar notions to what we saw in the first Trump administration. But then he makes one of his 5 pillars, artificial intelligence, which is different from the first administration. But I think overall, thematically, very similar policy perspectives and approaches, but the speed and the number of organizational changes that are accompanying this is quite different.
What trends are standing out to you?
I agree with Jeff. Energy dominance is a central trend to what the Trump administration is doing. I think this time around, though, one thing that's notable at the outset as compared to last time is, at least initially, we're not quite all of the above. You saw in the initial set of executive orders that there was, a pullback on wind permitting, and we've even seen a little bit of a pullback on solar. Now, that being said, the administration is obviously pushing fossil fuels, biofuels, and nuclear. So we've seen some early actions that are positive in terms of those types of energy. But I'd say the clear distinction at the outset between certain types of energy versus other ones is a little bit of a unique development in this administration as compared to what we saw last go around. But of course, we're very early, and we'll see how things develop on wind and solar, and whether some of the other things that the administration is doing, such as permitting, streamlining, encouraging the development of critical minerals within the United States, things like that, end up having positive impacts on those sectors as well in the long run.
Thanks, Shai. We've also been hearing a lot about the funding freeze and how that is integrated into different executive orders. How have you seen that impact the sectors you're looking at?
Sure. So there was a funding freeze that was specific to the Inflation Reduction Act and the bipartisan infrastructure law that was part of the Unleashing American Energy executive order. And that executive order put a freeze on disbursements specifically under those two laws. So that's definitely specific to energy issues. In general, the funding freeze, the administration pulled back on its kind of uh, economy-wide or administration-wise funding freeze. That's been the subject of litigation that we can discuss. But I think those two are that executive order is the one that really stands out in terms of its immediate impact on energy and environmental issues.
You mentioned that there's litigation on the administration-wide funding freeze. How have we seen that play out in court?
Well, a couple of district courts have enjoined the implementation of the funding freeze, I believe. There's the District of Rhode Island and the District of DC, which is interesting because the administration withdrew the executive order, as I indicated. Yet the courts have nonetheless gone forward in order the administration to continue funding activities, because I think they've seen, or they feel like they've seen evidence that despite the withdrawal, the administration is still withholding funds from certain projects. So those two sets of litigation, again, in the District of Rhode Island and the District of DC, are being appealed by the administration, and we'll see how those develop further.
On that point, Trump recently posted on social media, quote, "He who saves his country does not violate any law," unquote. And the federal district court in Rhode Island found there was evidence that the executive branch has continued to, quote, "improperly freeze federal funds." Are you concerned that the Trump administration is not acting to comply with the injunctions issued?
I think there's a statement that you mentioned, and there have been some statements by the vice president. So we'll see how those play out. On the other hand, the acting Solicitor General, Sarah Harris, went out of her way in some recent Supreme Court briefing to indicate that the government is complying with all orders issued by the district courts. And so there's things that politicians say, and then there's the way that the government acts. And I don't think we know what the ultimate direction of the administration is going to be in terms of compliance with all these court orders.
So we've got the cases to look at for the funding freeze. Can either of you discuss the administration's regulatory freeze?
Yeah, no, and I'm happy to take that one. Consistent with past practice across all administrations, the White House issued a regulatory freeze directive on day one, essentially telling the agencies to put pens down and to provide a window of opportunity for new leadership to review pending proposals as well as final rules that had not yet been published. And then also directing agencies to consider extending the effective date of rules that were not yet in effect. And that's consistent with past practice over many previous administrations. Now, there was an additional informal temporary freeze that was put in place by acting EPA Administrator Jim Payne for a short period of time to limit external communications from the agencies while new leadership was getting into place. And that caused a slowdown in some enforcement type meetings and other agency external communications while new staff were getting briefed up on issues. And that also was not terribly inconsistent with past practice. I think we're beginning to see some of those early temporary freezes work their way through the system and agencies returning in some areas to a more normal level of operation. However, there's still an ongoing effort to review and reconsider a whole host of regulations. One of the executive orders required each agency to submit action plans to the White House, identifying specific rules that they would review and reconsider, especially those that are viewed as posing a quote, undue burden on domestic energy resources. I expect that those efforts will be ongoing, and you could see some additional, and I think you will see some additional efforts by the administration to either stay or extend compliance dates or take other actions to roll back rules. On top of that, you've got this new 10-for-1 regulatory rollback requirement that essentially says for every new regulation the administration adopts, they need to find 10 to repeal. This is a sort of doubling down or quadrupling down or even more on what was the audacious goals of the first Trump administration in terms of regulatory rollback. And so we'll expect to see agencies giving more attention to efforts to not just freeze rules, but roll them back and roll them back in a major way.
And for our listeners, a rule in that order is not just rules that are final, it's also guidance documents and other policy documents.
Yeah, that's right. And I think also the way agency actions are defined in several of the executive orders go beyond just rules, can include things like enforcement initiatives and enforcement actions as well.
Great. Thank you for clarifying that. Moving back to issues of funding, since as we were discussing before, it's at the very least uncertain what will happen to large amounts of money that were appropriated under the Inflation Reduction Act and the bipartisan infrastructure law. Shay, how do you anticipate the Trump administration's executive orders will impact the ability of companies to obtain funding for energy projects in the future?
There's a distinction between funds that haven't been dispersed yet and funds that have already been committed. So, in terms of funds that have been committed by the federal government, where there's already been a contractual agreement and all the conditions of the funding have been satisfied, it's harder for the government to withhold that funding. To the extent that funding is withheld, I think we're going to see litigation on that moving forward. In contrast, to the extent there are conditions on funding, and that funding is in areas that are no longer a priority for this administration, I think you're going to see the conditions scrutinized very closely by the government. And that goes for grants and loans and everything else. I think it remains to be seen what's going to happen, but the committed funds, I think they ought to be dispersed. If they're not, I think you're going to see companies objecting.
Excellent. So, companies that are trying to see what's coming out of this new administration, Jeff, if you had a crystal ball and you were looking forward to what what do we think companies can expect to see when it comes to environmental enforcement under this administration?
Environmental enforcement will remain an area of focus for clients. And look, we work with a lot of clients and they're out there every day trying to do things the right way. They've got comprehensive environmental compliance programs. They take compliance seriously and certainly don't want to see themselves in a situation where they're facing enforcement. And I suspect we'll continue to see fairly robust levels of environmental enforcement across traditional enforcement programs and issues. Some have suggested that the new administration would totally abandon environmental enforcement. I don't think that's the case at all. I think you'll still see a healthy level of enforcement, but there will be changes in policies and changes in priorities. If we look across, take a 2-decade period of time, environmental enforcement, the number of cases that have been out there have generally declined fairly steadily from the mid 2000s. And the Biden administration made it a goal to reverse that downward trend. And to their credit, they achieved their goal. Over the last several years, there has been an uptick in overall numbers of new environmental enforcement cases. But looking ahead, I suspect we'll see that level out and perhaps maybe return to its more longer term downward trajectory. But still, I expect companies to remain vigilant on compliance. And then you have to also remember states are out there. They're going to continue to have their enforcement mandates and missions. And then you have environmental groups as well who could bring citizen suits to seek to enforce laws where they feel like the government has left a gap. So I expect enforcement will remain a key part and a concern for clients.
And final question for you both as we wrap things up. As companies adapt to new policy directions, what advice would you give to them about future proofing their operations, especially in light of potential legal challenges?
I'll go first and just say that companies obviously recognize that with a new administration, and especially one as active as this one is being in the first month or so of the administration, ought to expect some near-term uncertainty and upheaval, both in terms of policy and regulatory priorities, as well as interactions with the agency personnel who they might have grown accustomed to working with. And so you've got to navigate through that process. Looking out longer term, I suspect that we'll see active an active role for the courts. There'll be significant litigation challenging a lot of the regulatory change. Some of those regulatory changes businesses may find to their favor and might want to help step in and defend. Well, first on the front end to make sure that the comment process is robust, that the administrative record strongly supports the preferred course of action for the agency, and then working with your industry partners to defend those decisions on appeal, as litigation is certainly to ensue over many, if not most, of the regulatory rollbacks that will occur. But maybe there are some regulatory actions that are too disruptive or run contrary to a company's interests. And so that's an area where the administrative record needs to be built up. The agency needs to have the opportunity to review and consider those comments. But then maybe there are some actions that go too far, create uncertainty or disruption that's unjustified or unlawful. And those are opportunities where companies might need to look at stepping in and filing their own challenge.
Great. Thank you, Jeff. And Shay, do you have any thoughts on that question as well about how companies can future proof their operations?
I think Jeff covered the legal challenge aspect. I'd say in terms of future proofing the energy projects or the appeal of energy projects, I think it's important to put climate change to the back burner in terms of messaging and instead be focusing on energy dominance. And frankly, a lot of good projects both promote energy dominance and reduce greenhouse gases. Obviously, focusing again on the energy dominance part is going to get you further with this administration. But I think there's, again, a lot of good projects in the energy transition space that hopefully this administration will support because they do, in fact, make America more secure and independent and provide for a more robust energy future. So, that would be my advice to companies. And obviously, this is the way most folks are thinking, is to reframe these energy transition projects in terms of American security and independence, even if they also achieve the climate goals that were originally central to their selection.
That's excellent advice. Jeff and Shay, thank you so much for joining us. We really appreciate your time.
Yeah, thanks to Shai for that. And thanks both of you for coming on and sharing your expertise with us. We hope that you'll join us in a future podcast, and we appreciate you swinging by.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.